We invite and welcome you all for this IPR Cell webinar on patent filing and prosecution. Today we have with us Dr. S.P.SUBRAMANIYAN, Deputy Controller of Patents and Designs, Patent Office, Chennai. He's having a very rich experience in this field, from filing to various prosecution procedure in the filing office or IP office. He represented the member in UN Council of Patents for India once, and he is having a very rich experience in all the area of patent filing to till the completion of that patent or patent grant on post and pre-grant procedures. So we are lucky to have his session today, as now you know that patent office and all running, it's functioning, I think more than a month, though we are in COVID pandemic period. You know that IPR cell or IPR plays a major role in our life as well as our profession. Mostly we should be inventive. Be inventive, automatically we can go for filing of patents. I want to insist two things. One is quantity of patents and quality of patents. If you see the past 10 years history, Indian Patent Office is concerned, 10 years back, the quantity of patent is very, very less. That too, the contribution made by Indian community is very, very less when compared to foreign people. That means only 20% of the total patents are filed by Indians and remaining from abroad. But that is gradually increased over the period of 10 years. Now it gets increased more than 30%. And another point is quality. So quality can be measured by using granted patents. So out of total filing, the granted patent is, it's very, very less, around 15 to 20% only now. So that we need to focus. Then only we know, you know that the Global Innovation Index is a standard procedure, a standard measure to check our innovation status. So few years back, our Global Innovation Index stands at 80, rank of 80 out of 130 countries. But now we are in 52. Last 2019, we got 52nd rank. That is the basic reason is because of our Indian government has decided to promote an IPR policy that was launched in May 2015. So because after the launch of this IPR policy, government has introduced a lot of programs on IPR. Hope this program also will be promoting towards the objective and guidelines given by the IPR policy of Indian government. So with this note, I invite our resource person, Dr. S.P.SUBRAMANIYAN, Deputy Controller of Patents, Patent Office, Chennai, to provide enough information about this IPR filing and prosecution. Sir, the session is yours.
Good afternoon, everyone. Due to pandemic, last 3 months, we are home held. And this time, our entire scientific community around the globe fighting to find out vaccine, medicine, devices, and preventive devices. And mostly you can find now the requirement is vaccine and a medicine. And also some techniques or small devices required to identify whether a person is having this COVID-19 or not. Now we are only work in the home is to think and somebody writing the thesis, and some of you maybe deciding so many research topics. And I would like to ask you, please find out some solution to the community. It may be a device or it may be a drug. These two things we cannot easily get because it has to pass through 3 clinical trials, phase 1, phase 2, and phase 3. Then only we'll get. And at least to identify, to screen a patient, some device is required. If possible, you can find out, because most of the time our country is importing these type of small devices. But indigenously, through our Make in India and Made in India, we can do it. And Dr. Paramasivam already discussed about the importance, requirements, and how Indian applicants are filing patents and number of patents filed by Indians. Last 21 years, I am working in the patent office, Chennai, in various capacities, but I understand. Now, slowly there is a progress. Now, our scientific community and academic, particularly academic community, now they are finding out it is necessary to file a patent rather than publishing a paper. And quite number of patent applications we are receiving from many engineering colleges and other colleges. And the number is very impressive. And I request at least everyone in the academic should try to file one patent application in a year. Suppose if we take Kumaraguru Engineering College, say for example, 100 faculties are there. If 100 faculties are filing one in a year, it will become 100. And if you take 500 and add engineering colleges in Tamil Nadu, not out of 500, at least 250 colleges, if they file at least 100 applications or 50 applications, the volume will go up. Now I never like to compare with other countries, even developed countries, even with China. But we have potency, but our Indians are in the top number in all private companies, even in NASA also, our contribution is there. But India is an intellectual country, and why should we depend on the technology from others? But one thing you should know, and we should agree, most of the product, whatever we use, almost 95%, you can say 98% of the products, whatever we use day to day, the technology is not from India. It is a borrowed technology or a transferred technology from other countries. See, we were rich traditional knowledge in medicine and weaving technology, transportation, whatever you take. But we failed to convert our traditional knowledge with the modern science. But we have to find out a way to connect this traditional knowledge to the current modern technology. But today I'm going to discuss about patent filing and what is happening in the patent office, how the examiner and controller look the patent application and examine and evaluate before granting patent application. Most of the patent applications around the globe, research work, innovations, products, processes are from the universities and colleges. It is not from any companies like Apple or Samsung or whatever be the company. It is most of the research works originated from the universities. But in India, we are lagging it, but we have to find out gradually to increase the number from the company, from the college. And there are many factors involving in filing the patent applications. Maybe the administration not interested to file. The administration may not be interested to invest more on filing the patent applications. But it is the duty of the IPR cell and the faculty to make the people understand the patenting system. It is very much required for making the college the reputation in the higher level, so that it will help not only in the NAC rank or even for the academic side, student also prefer to come, and for ranking also it will help. Now, if you take the university in the West, most of their research work, they capture the IP. The IP may be a patent, IP may be design, IP may be a trademark, or IP may be a copyright. As soon as they start the work or whenever they do the research work, they capture the IP, they understand the IP, under which IP I can protect my knowledge. Then after filing the application, then they transfer the technology to company, maybe 3M company, or in many software companies required your software or even hardware. The technology is transferred from the university lab to the companies. The company make the product and make the design. For that, the company give the royalty to the university. Using that royalty, the company again involved in the research work. Most of the universities in the West, they run the university with their earning from their research work. This culture should come to India also. And the academic people, we always think in the positive angle. Today it may not be possible, and tomorrow or some other day it may be possible. But don't think that all the technologies, all the patents filed are workable or commercially viable. Only 20 to 25 patents granted are commercially viable, and most of the other 75% of the patent applications are patents to protecting the patent or the product, or the protect their knowledge from the public domain. Most of the research works, patents, almost 90% of the patents or improvements. Don't think that all the breakthrough inventions. There may be a small increment, small value addition, but that value addition you have to think that whether it is patentable or not. Academic people always their aversion towards publication. As soon as they do research work, they try to publish their information in the leading journal or any other high impact journal. After publication, the copyright you have already assigned to the journal. If you want to reprint, you have to take a permission and you have to pay and you have to get it from the journal. But you cannot do anything because the copyright already been assigned to the journal. Now, once you published, the novelty will go. Even after few months, also you cannot file a patent for your innovation. There are many occasions I received such information from the people. They published in the journal, and after 6 months or 10 months, they have come to know from other colleague or other friend in India or in abroad. It's a wonderful research work. You would have patented it. Then the people are trying to file the patent application. By the time they understand, since it is published, you cannot file a patent application. But most of the time, these journal publications are discoveries. But unfortunately, our Indian inventor, even for the innovation also, they published. But most of the time, the foreign universities, foreign academicians and scientists, they publish in the journal only the discoveries, not the innovations. But we have to change our attitude and mindset. We have to check whether the research work is patentable or not. Then you can go for a publication. If it is not fulfilling the requirement for filing the patent application, you can straight away go and publish in any journal. If it is within the purview of filing the patent, definitely you should file a patent. Cost is very simple. Now, first of all, idea come to your mind. That with that idea, you have to do search. Where to search? Most of the people, they search the Google Scholar or Google or some private journal database. But most of the time I said the journals only gives you discoveries. But patent database only gives the latest information, innovations, value additions. But you cannot get these information from any other source. As soon as you conceive an idea of doing something, if you want to collaborate with the other colleague, make a non-disclosure agreement, maybe within your college with other department or with some outside department or colleges or universities. You make a confidentiality agreement or non-disclosure agreement. It is very much available in the public domain. You can download such a agreement and sign because it's a binding. Whenever you are doing any collaborative research work, if it is a job work, suppose some instrument is not available in your college, you may have to go to some IIT or some other college. Then there somebody may ask you sharing your innovation as an applicant, but you can accept and you can give as an inventor, but not as an applicant, because they are doing simply the job work. They have to do whatever data you want, whatever your requirement, based on that they are doing. It is like a tailor. It's job work simply, making a Xerox. They are having Xerox machine. You want to take your certificate, simply they are making a Xerox copy and giving to you. So therefore, they do not have any right to be an applicant for your innovation. And you have to make a search in the patent database. And if you conclude you are going to file a patent, then file a patent application and then make a product. With that product, you can transfer the technology to the people and you can take the royalty. This is a sequence of from idea to products, and you have to be very careful while doing all this step by step and timeline. Patent is an exclusive right. It is granted by the government for full disclosure of your invention. This right, exclusive right or monopoly right, is for a limited period, that is for 20 years from the date of filing. It is simply you are disclosing your invention to the government. In lieu of that, government will give you a monopoly right, that is for 20 years. Disclosure means what? How do you disclose? You are going to disclose by a written description in a written document, which is sufficient enough for a person having ordinary skill to understand your invention. And there should be a best method of performing the invention so that without your knowledge or undue burden, a person working in the field can make the product, can use the process or method for preparing the product. For this written description, the government will give you a monopoly right for 20 years, by which you can exclude others from using it, and you can take a royalty for using your innovations. The right is a negative right, which is stopping others from using your invention. This right is a territorial right. People may ask, Sir, is there any worldwide patent? Many developed countries are trying for worldwide patent, but India is a leader for not allowing the worldwide patent. Worldwide patent means, suppose if it is granted in one country, developed country, all the member countries have to agree. So now it is a territorial right. If you file your patent application in India, you have right only in the territory of India. If you want to exploit your invention in other countries, you have to file separately in that country within the timeline, and then you can enjoy your monopoly right in the other countries also. According to section 21J of the Patent Act, invention means any new product or process. There is no boundary for any field of technology. After 2005, all field of technologies came in, because we filed WTO agreement in 1995. We took 10-year relaxation. From 1/1/2005, in India, we are granting product patent for medicines and food. And from the beginning, we are granting patent for engineering products. So there should not be any discrimination in any discipline or any field. So therefore, it is for any new product or process involving an inventive step and capable of industrial application. It should be novel, it should be inventive, it should be industrially viable. These are the three conditions for filing patent applications. Apart from these three conditions, there are two more conditions. The invention should not fall within the definition of non-patentable inventions. There are certain inventions under section 3 of the Act which are considered as non-patentable inventions. So the given invention should not fall within the purview of non-patentable invention under section 3 of the Act. And there should be enabling disclosure. I told enabling disclosure means a person skilled in the art, working in that particular field without any undue burden, using the disclosure, he has to come out manufacturing the product or preparing the product from the process disclosed in the patent application. First condition is novelty. What is novelty? Before filing your patent application, it should not be published or worked in publicly, and it should not be available in the electronic network, and even it should not be published as a book, journal, or in patent journals. So therefore, before filing, don't try to publish your inventions which affect the novelty of your application. Then the first condition will go if you publish before filing your patent application. Now, there should not be any prior publication, maybe article publication, any press release or conference, presentation, poster, and proceedings. One thing I would like to tell you, as soon as they invent any device, the professor and then associates and the students, they call the newspaper and they give you a post. The photo will come next day in the newspaper. This is not the right practice. As soon as you invent, try to file your patent application in the office, appropriate office, then you do it. But don't give any lecture based on this invention. Don't give any presentation. Even in the small group, don't do it, because it is easy to copy and getting idea is very difficult. And with that idea, creating a product is very much possible. So if you want to file a patent, seek anybody professional working in that field or consult your IPR cell before other people filing your invention. The cutoff date for novelty, suppose today you want to file your application, whatever published, whatever knowledge known to public before today is prior art. So therefore, you have to be very careful before filing your patent application. We should not publish or we should not disclose such information to the public. Second condition is inventive step. Inventive step means technical advancement of your invention, value addition of your invention. But that value addition, the technical advancement should not be obvious to a person skilled in the art. It is very much necessary. Most of the patent application passes the first test and they fail the second test, inventive step, technical advancement. But it is because of poor drafting and not disclose all the embodiments of the invention. You cannot collect the information publicly worked or available in the net from the different source and combining all this information and you can file a patent. Such a combination is obvious. When obvious, then definitely it is become non-patentable invention. Say for example, the first patent application was filed for caster for facilitating the movement of the chair, caster, the roller. Patent is already granted for that. The next patent application for caster for facilitating movement of disc. Since the second invention is also on the casters, it is not allowed because a person skilled in the art can use such a caster to caster or table or any other object which can be required to be moved. So therefore, it is not allowed. It is obvious to a person skilled in the art. Now there are three casters available here. Fine. Each have different, unique difference, the locking mechanism, and three are used in different places and to move the different objects. So therefore, some inventive feature, some value additions are there in these three casters. It may be possible to file separate patent application. It is not obvious. Industrial applicability. The last condition is industrial applicability. A bridge between earth and moon. It is impossible. It is imaginary. Therefore, it is not industrially viable. Therefore, it is not patentable invention. Second example, method of drinking hot tea. Man to man, it varies. It is not an industrial process. Therefore, it is not industrially viable. It is not patentable. Now, patent information is very much necessary for all the academic people. In my experience, I visited many engineering colleges. I received many academic people in the office. They are not searching in the patent database. Patent database, I said, it gives very unique information. 80% of the details are found only in the patents. So try to use the open source and free source for your research work. And 90% of the patent document is free to use and 10% only protected. Even that 10% for research work, you can use it. I prefer this website, worldwide.espacenet.com. This is a European patent website. Almost 68 countries, more than 68 countries patent documents are incorporated in this website. If you want to search in the Chinese, Korean, Japan, the US, European and Canadian, Australian, all the patent documents are incorporated in this website. You can make a single search in this website to retrieve the documents. But retrieving the documents is not easy because people try to disclose, at the same time try to hide the information from the competitor, from the skilled people. Suppose you want to search for automatic razor, the information may not be available under automatic razor, or it may be shaver, or it may be available under dehairing device, or it may be available under hair removing device, or even unhairing device. So therefore, you can use all possible keywords to retrieve the document. Like that, for aspirin, it may not be available as aspirin, maybe acetyl salicylic acid or anti-inflammatory drug or a cardiovascular drug. Searching is a challenge, but it is not much difficult. Over a period of time, you will be acquainted with all these things. It will be easy. Initially, you may face problem. Suppose you want to search for pen, but the information may not be most of the time available under pen because this is commonly used language. But in the patent document, most of the time people not use the common language. For pen, they use a writing instrument or writing device. So you have to search accordingly to retrieve the document. There are two types of searches. One is keyword search, other one is IPC, International Patent Classification. The people normally, they use different terminologies for legal implications, for the scope of protection, and hide it from the competitors. And once you acquire the knowledge of patent searching, it will be easy. But IPC is very easy. If you find out the particular IPC, International Patent Classification, for any invention, it will be easy to retrieve the document. International Patent Classification, you can find, it is classified subject wise, maybe agriculture, electrical, electronics, painting, and then textile, chemical, all different classification is there. Under different classification, there is sub-classification is there. Under sub-classification, sub-classification is there. Then it will go fine. Whenever the technology grow, the classification also they change, and then time to time they update. So try to practice keyword, screen the document. Then second step, you do IPC search also, so that you can retrieve the closest prior art, so that you can avoid complications after filing your applications. There are few websites. First website is IP India. This is Indian Patent Office website. You can find many informations, how to file a patent application, what is the fee structure, the various forms you can download, and you can find whether any patent application is filed in India on the particular subject matter. All this information you can get from IP India website. The second one is World Intellectual Property Organization website. And third one is, I said, European patent website, worldwide.espacnet.com. Fourth one is USPTO website. I told you the preferred website for a broad search is the third one, worldwide.espacnet.com. Filing procedure. Any true and first inventor can file patent applications. The true and first inventor can assign their right to a company, to a college, to universities. Because inventor invent a particular product or process, they are having the right to file if the inventors utilize the facilities of a college or university or any other research body. They have to assign their right to the college or university or the research body because they have utilized the resources of that institute. Now, inventor column, automatically your name will be there. In the applicant column, the college name will be there. They can jointly or alone, you can file a patent application. Patent is granted for one invention, one patent application. If more than one invention club together to file application in the patent office at the time of examination, the examiner and controller will advise you to divide the application and ask you to file a divisional application. Even if you club more than one invention, during the examination division asks you to divide your application to file one more application. So therefore, it is better to file a different application. But if the application fall under single inventive concept, you can file a single application, one device, and method of using the device and usage of the device. All three fall under single inventive concept, and you can file a single application. But you have to file it in the proper office, accompanied by a provisional or a complete specification. What is the appropriate office? If a person resides in Chennai or Tamil Nadu, he has to file it in Chennai office. Or from any of the southern state, the jurisdictional office is Patent Office Chennai. Maybe from Kerala, maybe from Karnataka, or maybe from Telangana or Andhra Pradesh or Pondicherry. All they have to file in a Chennai office because this is the regional office. The jurisdictions for all these southern states falls under Chennai Patent Office. How to file the application? Earlier, a person have to come and file the application, or he can send his application through post or courier. Now, two modes are available. One is hard copy filing, another one is online filing. 24/7, you can file your application through online. For filing your application online, you need to have a username and password. For getting a username and password, you have to take a digital signature from the authorized vendors. The authorized vendors and approved vendors are there in the website, in the IP India website. You take a digital signature, create a username and password, and you file your, enjoy the facility of online filing. You need not come to Patent Office Chennai to file your application. Now, for filing a hard copy, courier service is not allowed. You have to send it by a registered post. And by default, many of the people, they send by courier because they want to send the document immediately so that the courier will deliver 1 or 2 days. They may think that post may delay, but in the recent amendment, the hard copy should send by a registered post, not through courier. Keep it in your mind. But most of the time, we entertain DD, not check. For filing, there are few documents required. Number 1, Form 1. Number 2, Form 2. Number 3, Form 18. If at all your application you require, it is to be published yearly, then Form 9. If it is other than an inventor, then proof of right. If you engage an attorney, Form 26 is required. And sometimes the controller may ask whether you have filed any patent application in any other jurisdiction other than India. So therefore, with Form 3, you have to submit the details. For filing a patent application for an individual, for online filing, it is 1,600. For hard copy filing, 1,750. For a small entity, small scale industry, online filing is 4,000 and hard copy filing is 4,400. For the universities, companies, colleges, other than natural person, online filing is 8,000 and hard copy is 8,800. This fee is for 30 pages, less than 10 claims allowed. If more than 10 claims, then each claim we have to pay extra money, and over 30 pages you have to pay some extra amount. And request for examination, you need to file, unless you file the request for examination, office will not take up your application for examination. So it is mandatory to file request for examination as per TRIPS norms. The filing date is very important for many aspects. This fixed the day when the patent application filed in India to claim the priority of your invention. From this date, your patent term starts, not from the grant date. From the filing date, your protection starts. At the same time, your term of the patent, that period also start from the date of filing. For all purpose, it will be filing date will be taken for calculating the priority, for deciding the application for novelty, and also the term of the patent also calculated from the filing date. There are different type of applications, except 1 and 2. All the other cases, the specification, the technical details of your invention will be one and the same. In case provisional specification, the technical details with other document is same except claim. In the patent of adhesion, sometimes the description may be same or it may be different, and claim may be different, because this is the improvement over the known. Provisional specification, the name itself you can understand, it is a provisional. It is not the final one. But it should describe the nature of the invention. All the essential feature you have to disclose in the provisional specification. But there is no need to include claim. Suppose you have included a claim and filed, and you can request the controller before 12 months to treat the complete specification filed as a provisional, and you can file one more complete also. That is there, but it is a rare case. Very few people only opt that. The provisional specification, you have to disclose as much as possible, and it decides the date of priority and date of application, and the term of patent also start from this date of provisional specification. And certain thing you can value add, or you can fine tune, and you can amend before filing your complete specification. But all these things you have to complete within 12 months. Suppose if it is not possible to file the complete specification within 12 months, you can request the controller to post date for maximum of 6 months, and you can file a complete. That provision is also there, because somebody maybe in the traveling or maybe pandemic or not in a position to file, your work might not be completed. So to all these occasions, there is a 6 months provision. You can post date your application, and then you can file your complete specification within 6 months from that date. It protects the priority of the application. You can avoid somebody in between file the application. You have the liberty within 12 months to develop further. But you can disclose your invention with the non-disclosure agreement to obtain a financial support from any other people, because you can show, sir, see, I have filed the patent applications and the work is on. If you check the details, technical details, whether it's a commercially viable, then you can extend the financial support. And you can decide whether you can go further and file a complete specification or not, whether we can extend this innovation in other countries or not. But provisional specification can be filed where there is the urgency. How the urgency will come? Suppose you went to a seminar, accidentally you have disclosed, or meeting with any people, any commercial disclosure. During discussion, you might have disclosed all the technical details. You are worried, then immediately you can file a provisional specification. And during the meeting for a commercial disclosure, you have disclosed, or you have submitted your thesis. The thesis went to some other referee's hand. It is not published. Then that time you can decide to file a provisional specification. And there are many competitors. To avoid that, you can file provisional specification. Within 12 months, you have to file a complete specification. The complete specification and provisional specification is a techno-legal document and particularly describing the invention. The preamble in the Form 2 is the following specification particularly describes and ascertains the nature of the invention and the manner of which is to be performed. And all the details about performance of the invention, constructional feature, as well as the functional feature and method of doing it, you have to incorporate in the complete specification. There are certain, like your paper, research paper, article in the journal, this also having a format. That format, this office don't insist you to follow the format. But whenever you are submitting your article to a particular journal, each journal having a separate format. Say, for example, introduction, abstract, materials and methods, results, discussions, conclusions. These are some of the subheadings in the research paper. But likewise, in the patent document also we have the format, but in the patent India, we are not insisting. But title of invention, it is mandatory. Field of invention, background of the invention, objective, statement, summary, brief description about the accompanying drawings, and detailed description. It should end with claims and abstract. Now, title of the invention should indicate the subject. It should be within 15 words. It should not be more than 15 words. It should precisely indicate the subject. The field of invention means, suppose your invention related to biotechnology or a communication or a computer science, you have to record in the field of invention. As soon as your application is received in the office, there is an examiner to classify your application according to your subject and field of invention, so that your application for the examination will be allotted to the subject expert. In the background of invention, you have to give the closest prior arts. What are all the problems in the prior art? And what is your object of your invention? And what solution you are going to give? This you have to mention in the background of invention. And in the summary of invention, you can give a brief summary of the invention. And sometimes, and most of the people, they copy the claims and then they paste here. And mostly in line with the claim, they claim, because in the statement, they have to give the various embodiment of your invention. It is necessary. And also it gives better protection whenever you are going to show your patent document to the people for financial assistance or for any other thing, then it will be very much essential. And brief description about the accompanying drawing. If the invention involves maybe block diagrams or flow charts or any figures, then you have to write about the details of the drawing, what it illustrates. That brief details you have to give. In the detailed description, you have to refer the figure and constructional as well as the functional feature and working of that shall be incorporated in the detailed description. There should not be any descriptive matter in the figures. It may be a block diagram. In that block diagram, you should not write many things. Make 1, 2, 3, 4, 5, 6 or ABCD and refer that A or 1, what is 1, what is A in the detailed description. But don't write any descriptive matter in the figure. It should end with claim. There may be any tables or diagrams or flow charts or anything to define your invention, to describe your invention, which is easy for the examiner and controller to understand your invention. It should end with claim. Claim is a more important part which protects the monopoly right of your invention. So therefore, you have to make a boundary technically. But most of the time, Indian scientists, academic people, they are not taking care in writing the claim as well as the specification. Almost over 60% of the applications are rejected at the time of examination because of poor drafting and not disclose their original technical details, research work in the patent documents. In the claim, simply they write, I am the inventor. I have invented this. Nobody else in India has invented. This works better than other thing. So this type of statements nobody wants. Claim is technical details about the invention. What improvement you have made. You go through, before writing a patent document, please go through 1 or 2 documents which is already published, which is already in the public domain, to understand various topics, various subheadings, how they write for that invention, and how can you convert to write for your invention. An abstract within 150 words, it should indicate the subject and your research work. Claim. As far as claim is concerned, it should be a single sentence. There should not be full stop in between. You can keep comma, semicolon in between. Even if it run into half page or 1 page or 2 page, there should not be any full stop in between. So it is very important. Why? It is a legal document. It is a property registration document. You have to follow these instructions while drafting a claim. Publication. After filing your application, expiry of 18 months, your patent application will be published in the patent journal. It is a free publication. If any secrecy direction is imposed under section 35, that means if the invention related to any atomic defense, then the secrecy is clamped and it will not be published. So now you filed your application, the publication is 18th month. If at all you want to withdraw your application, before 15th month, you have to request the controller, you are going to withdraw the applications, or otherwise it will be automatically published. This is the publication format. The patent application will be there. Patent publication. This is the patent application number. Now this number system has been changed, and publication date, international classification, name of the applicant, name of the inventor, abstract, figure. And once it is published, any person can file a pre-grant opposition. Suppose somebody working in the university, they left their job and they work involved research work in this college or university. After leaving the college or university, they may file a patent application on their name. That time, you can very well file a pre-grant opposition, inform the details to the patent office. This information, this research work belongs to your college because it's illegally obtained and filed the patent application. So you can make a pre-grant opposition. This time period starts from the 18-month publications until grant of patent. You have the opportunity to do it. And your publication will become a prior art. No other can file similar application for such application, file a patent. Any interested parties, if they are attracted towards your research work, they can contact you, they can pay and take your invention, and there will be a negotiation. Suppose you want to do yearly publication, somebody want to submit their thesis, they want to leave the place. Along with the thesis, you want to keep the publication, then you can file a request for yearly publication, Form 9. Immediately within 3 weeks, it will be published. Sometimes within 14 days also nowadays is possible. For that, you have to pay additional fee. For a natural person, it is 2,500, and for other than natural person, 12,500. And nowadays, if you make application, a request for yearly publication, your examination also will be yearly, and there is a chance of getting a patent also yearly. Then another important document form you need to file is Form 80. This form shall be filed along with the application, along with Form 1 and Form 2. And it shall be within 48 months from the date of filing. If you miss that 48 months, it will be considered as deemed to be withdrawn. So therefore, file your request for examination within 48 months from the date of filing. That means 4 years from the date of filing. Now, examination. When the patent application is matured for examination, it will be allotted to the examiner controller pair. And this seniority will be based on the examination, request for examination, that is Form 18. And it is an automatic allotment system, computer allot, and it will be allotted to the examiner. And the examiner check the formal and technical objections, and the file is thoroughly read and analyzed. The controller will make a search for novelty and inventive step, not only the document published in India, around the globe. And he come to a conclusion and take the relevant documents and makes his report and argument with the citations, how closely the prior art relate to your invention, and gives the gist of information and compare your invention and make his objection whether your application invention is novel or not. This is based on section 21J. It says about the invention, it is new or inventive or industrially viable. Section 3 talk about not patentable inventions. Section 4 is the invention related to atomic energy. Section 10 talks about the content of specification and how the complete specification shall be, whether any enablement disclosure is there, whether the complete specification is properly drafted to understand the invention, and whether the amendment made, voluntary amendment has been made within the scope of the first filed application or not. This they check. And the gist of formal and technical objection will be forwarded to the applicant or the inventor as a first examination report. This report is called first examination report. In that first examination report, there are prior art details. Prior art detail means publication number. If it is a journal, journal name, volume, page number from to, and author name. If it is a patent document, US patent document, it indicates US, then patent document. If it is a European document, it indicates EP followed by the number. That prior art details will be provided. And I said the gist of information in the prior art, which is very close to the present invention, also will give you. And what is the difference? What is the closeness? All these analysis, and then the report will be sent to you. And in the first examination report, there will be indication you have to pay any pending fees or any form you have not submitted, need to be submitted, or any petition. All this information will be informed you. And the controller also indicates you amend the claim in a particular fashion. That suggestion also, it will be indicated in the first examination report. After receiving the report, the inventor or the applicant can either decide to continue with the examination or simply withdraw his application. If he wants to continue, then he has to read the document, prior art document, each and every document, whether it is close to your invention or not. Because most of the time, the report will contain all these prior art documents, and the inventor, you only know how close the prior art documents with your invention. And you can make and fine tune and what inventive feature make your invention inventive and novel. That you have to give in a crystal clear so that the examiner and controller will understand the invention. And if anything claim is required to be amended, you amend and submit. Then the inventor submit his reply to the examination report, first examination report, within 6 months from the date of such report. Suppose you are unable to complete within 6 months, you have further time, 3 months you can take extension by filing Form 4. That extension need to be filed within this 6 months period, not after expiry of the 6 months. So 6 plus 3, 9 months for the reply to the first examination report. Then you submit in a written form, and you can, anything, any clarification required, you can call or you can send a mail to the examiner for any clarification. After receiving the report in the patent office, the examiner once again examine your case in line with your reply and the amended claims and the prior arts and whatever statement you have made. With that, he will examine, and if he find no formal and technical objections, straight away it will be granted. Still, he suspect whatever you have submitted, the reply is not satisfied, then again, he will recommend for a hearing. The examiner recommend for a hearing to the controller. Then the controller read all the objection made by the examiner, and either he can accept all the objections or he can reject all the objections, he can grant. If he accept all the objections, he can send a gist of information along with the oral hearing notice, fixing the date and time and notify to the applicant. The hearing may be personal or through video conferencing. You may opt, the applicant may opt, sir, I would like to come and present before you personally, or you can opt for video conferencing hearing. Either way, it is possible. But the particular time and date, you have to be present. If you don't attend the hearing, automatically the controller will decide the case, you are not interested to proceed with the case, then it will be refused. After the hearing, the inventor or the applicant can modify the claims, and then he can submit it to the controller with the written statement, with the written argument, you can say that the controller, if he accept, then he grant. If he don't accept, then he will refuse the case. This is the format of the patent document. And the controller not accept your case, he will issue a decision with the speaking order. Why he is refusing? What is the reason for refusal? Each and every point he will discuss and refuse your application. If you are agreed with the decision of the controller, you can approach the intellectual property appellate board within the timeline, or you can request the controller to review his decision under the provision of the act. After grant of the patentee has to pay the maintenance fees, renewal fees every year before the last date. And if he cross the last date, he can get the extension and he can file. But this is possible up to 18 months. If it is 18 months, it will be automatically ceased. Then within 18 months, you can file a restoration of the patent, and there is a possible for reviving the patent. And every year you have to submit the patent is worked in India and working of patent shall be submitted. After grant, it will be published in the patent journal. Within 1 year from the publication, any person interested can file a post-grant opposition in Form 7 to the controller and copy forwarding to the patentee. The fee for a post-grant opposition is individual 2,400 and small entity 6,000 and a company 12,000. I said, if you are aggrieved, you can appeal, you can make appeal in the Intellectual Property Appellate Board, which is located in Chennai. This IPAB decision is appealable in the High Court Divisional Bench. I said within 18 months, the lapsed patent can be restored in the patent office. What to do with the patent? And many of the patent, we simply receive the patent document, we frame it and hang it on the wall. But please ensure that the patented technology is used in the industry or used by the industry and the technology is transferred. I said 25% of the patented technologies are commercially viable and remaining are cluster or maybe protecting the old one or protecting their knowledge. After receiving the patent, you can manufacture or you can sell the technology region-wise or whole world. You can sell this, you can give a license or you can assign, you can give a gross license, and you can make a further improvement doing some R&D and making patent of addition. You have to pay the renewal fees and you have to inform the patent controller that the patent is worked in India. Amendment. Sir, I filed application. I changed my address. Yes, change of address can be submitted to the patent controller by filing Form 13. In between, one company has merged with the other company, or the company name itself has been changed. Then change of name or merging, everything is possible by filing amendment. Or in response to the first examination report, you want to make any amendment, it is in response to the FER, there is no need to file Form 13. This amendment can be filed before grant or after grant till expiry of till expiry of the patent. Amendment may be for the name, address, technical details of the specification, including claim, possible. IPR cell is there, many engineering colleges or some of the colleges, it is for the namesake, they are having the IPR cell. It is not fully functional. And I request the people watching this webinar, if IPR cell is there, try to utilize the IPR cell, or people handling or people using this IPR cell, try to keep a stock member, at least knowing the knowledge of IPR, knowing the knowledge of patents, and search how to search in the patent database and how to draft the document, what are all the procedures before the patent office, and timelines for filing Form 18, Form 9, and Form 6, all these things, and how to submit, and the fee structure, the IPR shell people should know. And the IPR shell should should dispose whatever the documents they receive, research or they receive, in a speedy manner, and learn all the subject and learn the IP and convert all the project into patent and support and protect your college for the development of the college, for the reputation of the college, and try to file a patent application in the appropriate office in the appropriate time and commercialize your patent, and then share the benefit with the inventor as well as the college and with the alumni. With this, let me conclude my session, and I request the people, is there any question? Because I was allotted for the limited time, I think I have not crossed. Thank you very much for the patient hearing. Any questions, please?
Sir, we have questions. Thank you for your nice presentation. We have a few questions.
Okay.
Is it possible to patent work published in a journal?
No.
And next question: the difference between paid published and free published journal papers.
Sir, we take it as a publication, whether it's a paid paper or free publication. It is for the journal, we don't mind. But here in the patent office, after the expiry of 18 months, there is a publication called free publication. That is 18-month publication. And for yearly publication, you have to file Form 9 with the required fee, and it will be published within a month. And you can take a printout and you can keep it along with your thesis, or it may be communicated to anybody for record purpose. These are the two publications. Is it clear? Or
Sir, I think once it is published, both the ways are same, right?
yes, both are same.
Both are same. Okay. That's what they. It's free or paid website. I think they mean that eSpaceNet website they are asking. I think by the time only they asked this question.
No, eSpaceNet.com is a free. All the patent database are free. If you take US patent, European patent, or Canadian patent, Austrian, all the patent offices, their databases are shared freely to the public. 24/7, you can do it. Suppose you are searching in the European patent website for a Chinese document. There is an option, translation option. You can translate into online translation into English. You can take a printout or you can copy. So such facilities are there. Try to utilize those facilities.
Okay, then how we file our patent without paying any money?
No. There is no chance of filing any free patent application. If you want to keep your innovation in the public, simply you can do it in any newspaper or any free website you can publish. Let the public can make use of it. But there is no country is allowing any free patent. You have to pay the fee for each and every action because it's a property registration. Unlike other property, movable and immovable property, you are registering your property in the office. It is not simply a research work. It is a property. So therefore, fee involved. That to a family, if you go with the family in a good restaurant, minimum 5,000 rupees you are going to shell out, right? But 1,600 only filing a patent application, very minimum in India.
Yes. Next question is, sir, any specific language for writing patent or journal writing?
English. In India, as per the document, English or Hindi, preferably English.
Next question, how does one keep track to file a pre-grant opposition? It is essential to track all published articles in the patent journal. Is there anyone offering such service?
No, they are professionals. Suppose if you it is not possible for you to search every week because you are busy in academic, or even people are having the company or industry people. Industry people, they engage the people, and their duties to watch every journal publication, and within timeline they submit their document. Agents are offering these services. Patent agents.
Examiner, how long they will take to grant a patent?
Examiner simply examine and submit their report. They have to submit within a month after receiving the document. Based on the load, they will dispose.
Okay. Should we review every year? I think they are asking renewal.
Renewal, yes, every year they have to pay. Starting from third year, not first and second year. From third year, they have to pay.
Whether that means after granting?
After grant.
They are asking the difference between inventors and applicants. That what are the
See,
legal?
there are, I understand. There are two rights involved here, inventor and applicant. One is a creator and another one is investor. That is moral right, economic right. Moral right always with the inventor. Economic right always with the investor or the producer or the a person who is providing all the infrastructure. So applicant is having the economic right. Inventor is having the moral right. The inventor name will be there, even expiry of patent. Whenever the patent is referred, inventor name will be there. Applicant name may be there or it may be changed. Today, say for example, Kumaraguru College is inventing one wonderful machine for identifying COVID-19. Then tomorrow, this may be sold to Samsung or some other company. The applicant may be changed, but the inventor, those who invented that product will be referred, will be same in those documents also. So therefore, applicant is having the economic right, the inventor is having the moral right.
Another question, sir. If a patent is filed with the wrong title and inventors of the same university and it is published also, is it possible to change the title and author name?
Yes, title is very much possible, but the inventor, if it is filed from a college, then the college administration has to give a statement in the affidavit, and other inventors already disclosed at the time of filing, they have also accept, yes, he is also inventor. These three affidavits need to be submitted in the patent office. It is a typographical error. We have missed one of the inventor. So therefore, it may be included. That is only possible.
Thank you. What is the government support for patenting, especially financial support and commercialization? Is there any such?
Yeah, science and technology, MSME, or many organizations or DIT, they are providing support for filing and then for making small pilot product. The government is supporting.
NRDC also supports.
Yes, NRDC also supports. But patent office is a granting authority. It will not support any financial or any technical support. From the officers from the patent office, you can go and ask their opinion and then their directions.
How many members are allowed in patent filing in inventor's part? Is there any limit?
No limit. Maybe 100 also.
In that case, all are having equal credit, equal right or equal credit?
Yes, yes. It is not like your journal. The first author and the last author having a weightage, different weightage. But here all are equal. I said it's a property registration. If the property registration contains more than 3 names, okay, everyone is having equal right. Suppose the percentage is mentioned in such a document, then according to the percentage they will get. As far as patent document is concerned, only disclosing the inventor, but you cannot keep every name in the number 1, 1, 2, 3 like that you have to write, right? So therefore everyone is having equal right. There is no difference.
Another question. Sir, I have filed a patent in India in the year 2011 and got grant in 2019. But meanwhile, the same work got grant in China. Is there any way to defend it?
Yes, the pre-grant and post-grant according to the Chinese provision, you have to do it. You have to file a opposition in Chinese patent office.
After getting patent, any way to cancel the patent anytime?
Yeah, you can surrender your patent to the patent office. You can surrender, very well surrender. That is, surrender provision is there under the Act. You can surrender your patent.
I think we are reaching last part. A few more questions.
Okay.
Where do I find already patent technologies or methodologies?
That is, I said, the collection of information is available. https://worldwide.espsnet.com. And if you want to search only for India, you can search Indian website, ipindia.nic.in.
What is the cost of patent maintenance amount after grant? I think
so
they are
every year it changes. For 3rd, 4th, 5th year, the same rate. And then after a year, the revised rate is there. But you can check it in the schedule. The website, it is available.
So good evening, everyone. I am Mathankumar, Assistant Professor in Electrical Department, Kumaraguru College of Technology. So it's my pleasure to propose a vote of thanks on this occasion. So first of all, I would like to thank our chief guest, Dr. S.P.SUBRAMANIYAN, Deputy Controller of Patents and Designs, Chennai office, for his gracing webinar. Thank you, sir, for your very interesting and thought-provoking lecture. I would like to express a gratitude to our management, principal, and our communication team for their cordial cooperation. I am happy to thank the participants who have turned up in good numbers and making this webinar a grand success.